Ever heard the saying, no good deed goes unpunished? Well, today's story is a perfect example of how trying to help someone, even family, can backfire spectacularly. This isn't just any courtroom drama. It's a tale of family ties, financial hardship, and a very, very expensive mistake. Meet Mr. Damer, a business owner who found himself in a legal battle against his former son-in-law, Mr. Poling. Now, you might think a divorce would be the end of their story, but it was just the beginning. Damer's daughter and Poling divorced back in 2009, and after a custody dispute, Poling ended up with primary physical custody of their child. Despite the family split, the two men actually maintained a professional relationship. Poling worked for Damer's company, and things seemed, for a while at least, functional. This is where the trouble starts. Poling needed a car, but his credit wasn't great. So Damer did what he thought was a good thing. He agreed to co-sign an auto loan for him. The deal was crystal clear. Both their names were on the title, sure. But Poling was 100% responsible for everything else. The monthly payments, the maintenance, and most importantly, the car insurance. The car was, for all intents and purposes, Poling's to use and his to pay for. Damer was just the safety net, the co-signer who made the loan possible. What could go wrong? Well, the working relationship eventually soured. Poling quit his job at Damer's company, which put a major strain on their already complicated dynamic. But the car loan was still there, a constant reminder of their connection. To his credit, Poling kept up with the car payments for a while, right up until January of 2014. But there was a ticking time bomb he had set months earlier. In court, Poling admitted something crucial. In October of 2013, he let the car insurance lapse. He stopped paying for it. Why? He claimed severe financial hardship. He told the judge that his brother, who lived with him, had failed to pay his share of the rent. Poling said he was faced with a terrible choice: pay for car insurance or pay the rent to keep a roof over his child's head. It's a tough spot, no doubt. He chose the roof. But here's where fate, or maybe just incredibly bad luck, stepped in. On October 31st, 2013, Halloween night of all nights, and in the very same month he dropped, the insurance disaster struck. A massive flood swept through the area, and the uninsured car was completely destroyed. It was a total loss. Imagine getting that news. Your car is gone, and you have zero insurance to cover it. After the flood, a tow company hauled the ruined vehicle away, but they didn't take it to a junkyard. They towed it directly to Mr. Damer's property and just left it there, a mangled monument to a broken agreement. It sat there, abandoned, while the loan balance loomed large. And how large was that balance? Court documents revealed a staggering figure: $12,479.11, almost 12.5 grand still owed on a car that was now a heap of scrap metal. So Damer takes Poling to small claims court to try and recover some of his losses. In the hearing, Poling didn't deny that the debt was his responsibility. He admitted it, but he tried to shift some of the blame. He testified that a month before the flood, back in September, he had actually called Damer and asked him to come and get the car. He told the court he knew he couldn't afford the expenses anymore and wanted Damer to take possession of it. He was essentially arguing, hey, I tried to give it back to you, you didn't come get it, so this isn't entirely my fault. How do you think the judge reacted to that defense? She wasn't having any of it. She looked at Poling and laid down the law, plain and simple. She said that his financial struggles, while unfortunate, were not a legal excuse to break his agreement. His primary obligation was to keep that vehicle insured. Why? To protect the co-signer, Mr. Damer. The judge pointed out that Poling might not care about his own credit score taking a hit, but as the co-signer, Damer certainly cared about his. Damer's financial reputation was on the line because of Poling's decision. The judge was firm. Asking Damer to come pick up the car didn't absolve Poling of his duty. As long as that loan was active and the car was in his possession, it was his job to insure it, period. Now, here's the final twist. The judge ruled decisively against the defendant, Mr. Poling. So what's the takeaway here? Co-signing a loan is a massive risk, even for family. It means you are just as responsible for the debt as the primary borrower. If they fail to pay, the bank will come after you. And if they fail to insure the asset, you could be left holding a very, very expensive bag. This story is a powerful reminder to think long and hard before you put your name on that dotted line. For Mr. Damer, his good deed cost him thousands of dollars and a trip to court. For Mr. Poling, his difficult choices led to a legal judgment against him. A tough lesson for everyone involved. What do you guys think? Was the judge's ruling fair? What would you have done in Damer's or Poling's situation? Let me know your thoughts down in the comments. Thanks for watching. And if you found this story interesting, make sure to like and subscribe for more true courtroom tales. See you next time.